Advocate Mashuga, we are going through the swearing-in process. Let me just make this remarks before we say you in that you have been invited before this ad hoc committee, which is investigating the allegations that have been made before.
Chairperson, I stand to be corrected. I have had I've consulted with my leader, and he's also of the view that perhaps the public participant should go first because his time is limited, and it's 45 minutes, and then thereafter we will take the main witness. Okay.
What do you want us to do?
Sorry, Chair, honourable members. I had requested at the last committee meeting to start with Advocate Mashuga at his request and that of his legal team. I had then asked to be excused from the meeting. So I didn't hear subsequently that request wasn't granted or refused, or what the position was and the order of witnesses. And that is why, after consulting with Advocate Mashuga and his team since yesterday, we were under the impression that we are starting first. And I think we still have Mr. Adams on our witness list for today. But in the event that Chair, the public participation witness, Mr. Chetty, are you going to restrict him to time? It may be best in the circumstances. Otherwise, he may well be waiting here, as Honourable Kusana said, for a long time. And if you can deal with him first, then we wouldn't have any objection.
What is your proposal?
So we propose that he start first, and that Advocate Mashuga follows.
Honourable Chair, I have not consulted with anyone. There's a lot of evidence that I have that I think council has to see, just instead of reading my affidavit in.
Mr. Chetty, the legal team tells me that they are fine. They can handle your matter. Remember, with public participation, it's not like the witnesses that we have identified. With public participation, they read your statement. They say that they have gone through your statement and they have structured questions, which they will ask you and help you to provide. When they go through your statement, they look at what is relevant to the terms of reference of the committee. You have given us your statement, isn't it?
Honourable Chair, yes, I have. And there's a lot of annexures as well, which I don't know if council has been through it, because there's a lot of information that has everything to do.
No, it's fine. Let's do this. Advocate Arense, let's take Advocate Mashuga for now, so that we do not do with the witness what does not give him or her comfort. If he thinks that on his part, I mean, on the part of the legal team, you may be satisfied that you are ready. So have that moment with him and satisfy him that both parties are ready for presentation. Yeah. Honourable Matthews.
Chair, we've discussed this quite regularly in our working meetings. that our public participants should not be treated any differently than the witnesses that are on our list. And while we made a decision as a committee based on the report that we received from our technical team, there was a process where our legal office is supposed to go through that and treat our witnesses and our public participants with dignity. We can't have our evidence leaders only getting these copies and then just going through it now, Chair. And this thing was even raised yesterday. Why are we doing that? And we've had so many of these issues. That's how we ended up having a witness here, because we brought them here without us just doing basic due diligence on it. Because remember, we made it a decision, Chair, as an ad hoc committee, based on just a report from the technical staff that they went through. None of that was tested. They were not sat down with the evidence leaders. From what I understand yesterday, Advocate Mkhize said they don't have capacity to be able to go through our public participants' sworn statements. So I would have thought that maybe we should see if the Parliament legal team is able to do that, but they're also the ones that don't lead evidence. So I don't think we're doing justice to this process of public participants, and we should not be treating the general public in the manner that we are, Chair. Thank you.
Honorable Nombalo.
Yeah, Chair, mine is a clarity-seeking question. I just need to be clarified on this aspect, Chair. Is Mr. Chetty a witness or a public participant? I'm asking this because I've read his statement, and to a certain extent, he's making a testimony which is within the context of the terms of reference, and a testimony which also involves some institutions that we are probing or we are investigating. So he talks about IDEC and so on. Now the question is, Chair, what is the difference between his testimony and the testimony of Advocate Mashuga? And I think we did discuss about this at some point as this committee, that what is the difference between a public participant and a witness? So I just need to be clarified, Chair, because I'm really confused. This clarity is important so that we have a better insight when we are dealing with witnesses, because the public participants that we have dealt with previously have been afforded an opportunity to make presentation, and if my memory serves me well, some were just reading presentations, which was not made under oath, which was not reliant on affidavits, on sworn statements. Now, Mr. Chetty is a witness. I mean, he is coming with a sworn statement and is making a testimony, which also relates to some of the terms of reference and also relates to some of the institutions that we are probing. So I just need to get a distinction, Chair. I'm asking this from a genuine perspective because I'm really confused now. What is happening?
Chairperson, the evidence team goes through all the affidavits that we receive from the Secretariat. We received Mr. Chetty's 75-page affidavit yesterday. He had initially filed a one-pager as his evidence as a public participant. He subsequently also attached a number of annexures, which are quite lengthy. I have gone through all of that overnight, and I am prepared to lead his evidence. He is a public participant in my understanding, and how we have dealt with all public participants is that we don't have numerous consultations with them as we do with witnesses as given to us by the committee members, because the list is received from the committee regarding witnesses. However, it does not mean that we compromise all witnesses that come before us. We treat them the same. we consult with them, we go through their evidence, we prepare, regardless of the time when we receive their affidavits. Indeed, I can confirm I have gone through his affidavit and I've prepared to lead him this morning.
Okay, let's do this because he has said that he wants to meet with you. We are going to afford you that time so that he gets satisfied that when you come back here to start the presentation of evidence, we don't have question marks. So we are going to start with Advocate Mashuga now and allow you, as it was earlier requested, that you will go and consult with Mr. Chetty, just for the legitimacy of the process, but also to have each one of you satisfied that whatever matter they would have want to raise, the matter is raised. Yeah. Honorable Ngala.
Chair, I'm quite concerned. Was looking also at the evidence of Advocate Mashuga. It's quite, it has got serious volumes. So I'm worried about the approach that we're taking now. If when they are done, the Advocate Mkiza and Mr. Chetty, are we going to interrupt the evidence of Mr. Mashuga, or we're going to take him immediately after?
We're taking Advocate Mashuga and from start to finish. Yes. Yeah. Advocate Mashuga, let's restart the process that I was explaining to you, that you have been invited here to come and help the committee in its oversight and investigative work. We are investigating allegations that were made by the KwaZulu-Natal Police Provincial Commissioner, General Nhlanhla Mkwanas. Amongst the allegations that he made is the unlawful, number one is the alleged unlawful disbandment of what is called the the political killings task team, otherwise known as the PKTT or NPKTT. Number two, alleged moratorium on the filling of vacancies. And within the South African Police Services, the SAPS. Number three, alleged corrupt relationship between senior leadership within the SAPS and members of the public. And lastly, political interference within the work of the SAPS. In extending this invitation, the chairperson of that ad hoc committee has indicated that you may provide such information to the committee if you so wish, under oath in terms of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act of 2004. Advocate Mashuga, please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to do so in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or even civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or a Committee of Parliament may not be used against you in any court or place outside Parliament except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading, commits an offense and is liable to a fine or to an imprisonment for a period not exceeding 2 years. You are required to take an oath or affirm that the evidence you are about to give is truthful. Which one do you elect, oath or affirmation?
I will take an oath.
Okay, thank you so much. You have elected to take oath. You shall, may you please follow me as I dictate. Please say aye and state your names in full.
I, Mulatwa Michael Mashuga,
Swear that the evidence I shall give
swear that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
And so help me God.
So help me God.
Thank you so much, Advocate Mashuga. I'm handing over the reins to yourselves, Advocate Mkize and you. Good luck in the presentation of your evidence.
Honorable Chair, I'm going to lead Advocate Mashuga. Just a few preliminaries before we start, Honorable Chair, Honorable Members. You would have seen from the affidavit before you that Advocate Mashuga has not disclosed his current position, where he's employed, and also his address. The reason for that, Honorable Chair, Honorable Members, is that you would also have seen from his affidavit that as a senior state advocate, he had prosecuted a number of high-profile matters, some of which have been concluded and successfully, and where the accused were found guilty and serving prison time. Other matters are still pending, which have now been obviously taken over by his former colleagues now that he's left. In one matter, the well-known or notorious rhino horn matter, where he prosecuted, threats were made to him and the investigating officer in that matter, and the investigating officer was murdered. So he is very concerned about his security and his safety. And in fact, just this morning, his legal team had also raised somewhat disappointment about his security arrangements that they thought would be made with Mr. Romano. So that is the reason, Honorable Chair, that is not disclosed in his affidavit and to this Honorable Committee.
But have those security arrangements been sorted now? Or are you still in the situation you were at the time he raised those concerns with you?
Mr. Maga of the MPA indicates no. So perhaps while Advocate Mashuga is in the relative safety of this chamber, maybe my colleague and Mr. Maga can try and sort it out with Mr. Maga.
But was there a commitment on the part of Parliament to make those arrangements?
I'm not sure, Honorable Chair, Mr. Maga is present. If with your leave, he can address that issue.
Thank you very much, Chairperson. He had made a request when he was requested to come and testify or prepare to testify before this committee. And all that he was provided was a driver, nothing relating to his security was addressed. He brought this to my attention yesterday, and I raised it with Mr. Romano and counsel this morning. And up to now, no indication if the matter is being addressed or not. And to us, that is a concern. Thank you.
No, it's fine. Let's proceed. We will get Mr. Mpilo as the proceedings go ahead to and solicit an explanation as to what is happening.
Thank you, Honorable Chair. And again, just before we start, just to contextualize Advocate Mashuga's presence here, he is giving evidence in relation to the again well-known / notorious case of Camildriff, case 1201/2017, which has been referenced in the evidence respectively of Mr. McBride, Mr. O'Sullivan, General Baslani, and that is why this honourable committee, through you, Chair, had requested that the prosecutor in the case, as we know, the matter was struck off the roll in terms of 342A of the Criminal Procedure Act some 7-9 years ago, and has not been re-enrolled. And the honourable committee was rightly concerned why that has not been the case. And Advocate Mashuga is here to assist us in that regard. He was the prosecutor in that matter. Now, this honourable committee wrote to both the previous NDPP, Advocate Patoy, and the current NDPP, Advocate Motibe. There was a letter that was sent to the committee in November last year by Advocate Patoy, and there's also a letter that was written by Advocate Motibe, and I've asked that it be placed on the desk. Will be in front of the honourable members, and it's also before Advocate Mashuga. If I may just refer to the first one, dated the 20th of February 2026. Advocate Mashuga, you've got that one? There's two, the one of the 18th. I'm going to deal with that one second. The first one is the 2-pager 2002-2026.
The one that I'm having.
You should have two.
18 February.
Yeah, and then there's another one of the 20th of February.
Yes, I have one.
Is that one page?
Oh,
yeah.
yes.
Yeah, and you have it. Thank you. Now, Honourable Chair, Advocate Mashuga, that's the one where, because of course you are no longer in the employ of the NPA, and you're a former prosecutor in the matter, you had to seek permission from the NDPP to testify.
Indeed, so Chairperson.
And this is the letter from Advocate Motibe, where he says in the third paragraph, I have seriously considered your request and henceforth authorized Advocate Mulatwa Michael Mashuga to disclose the information relating to the criminal case that involved Mr. Paul O'Sullivan, particularly case 1201/2017. Kindly note that the authorization is limited exclusively to disclosure for the purpose of the ad hoc committee. You are reminded that this permission does not constitute a general waiver of confidentiality obligations under the Act, and disclosure remains subject to the restrictions and protections provided therein. Any disclosure made under this authorization must be handled responsibly with due regard to the integrity of the information, the rights of affected parties, and the statutory obligations of the NPA. This authorization is granted solely for the facilitation of the ad hoc committee and shall lapse upon its conclusion. No further disclosure for any other purpose is permitted without the prior written consent of the NDPP. Do you confirm that, Advocate?
I do confirm receipt of this letter, and I confirm that the contents were so received. And in my affidavit, I try as much as possible to ensure that the conditions that were set out in this letter are complied with.
Since your resignation from the NPA in 2024, which you referred to in your affidavit, have you had access to the docket in this matter?
No, I never had access to that.
Good. And then if I may just round this off, there's a letter of the 18th of February 2026, which responds, Honourable Chair, to a number of questions posed by this Honourable Committee. Have you got that one there?
Yes, I do have it, Chairperson.
And where Advocate Mutibi refers to the Honourable Committee's letter of 10 February 2026 and the letter written by Advocate Batoy of 17 December 2025. Advocate Mutibi, our current NDPP, says that he has requested the Acting Director of Public Prosecutions within whose jurisdiction this matter resides to provide with a report to address further information. The ADPP has provided a report and the following response. The first question: why was a decision taken by the NPA to hold over the decision to prosecute O'Sullivan until the matter against General Pashlani is finalized? The answer: the ADPP was informed that the senior state advocate assigned the matter prepared an indictment that included charges relating to the contravention of Section 2 of the Prevention of Organised Crime Act, POCA, commonly referred to as racketeering. The POCA requires that racketeering charges require authorization of the NDPP. After due consideration of the said charges, the supervisor held the view that there was insufficient evidence to prosecute on racketeering. The prosecutor was directed to reconsider the appropriate charges. The decision by the prosecutor was thereafter delayed. Mr. O'Sullivan allegedly defamed the prosecutor, and the prosecutor also had to justify allegations made by Mr. Robert McBride at the Zondo Commission. The prosecutor has resigned from the NPA. So, Mashuga, that's a reference to you.
Indeed, Honourable Chairperson.
The ADPP has established that the docket is with the counsel appointed in the civil case and will be assigned to a suitably experienced prosecutor to consider whether to institute a prosecution and whether the case can proceed against O'Sullivan. The second question: whether the report was supposed to be compiled by the prosecutor within 7 days of the judgment did serve before the Director of Public Prosecutions. And Mr. Mashuga, that you're going to deal with in your evidence.
Indeed, Honourable Chair.
Yeah, this comes from a portion of the magistrate's judgment that the matter is removed from the roll and that the report must be compiled within 7 days.
Indeed, Chair.
Okay. The answer: it is assumed that the report referred to is the order made by the magistrate during the striking of the matter from the roll in terms of 342A of the Criminal Procedure Act. Section 342A3C of the CPA provides that the prosecution shall not be reinstated without the written instruction of the Attorney General. That was then the Attorney General, but it's the DPP these days. A report will only become relevant when the delay causing the striking of the matter has been addressed, e.g. further investigation that had to be finalized. In this instance, the DPP was appraised of the court reasons for the striking of the matter. There was no formal report, as it will only become relevant when it is considered to re-enroll the matter. So the concerns, Advocate Mashuga, that's been raised by this honorable committee about why the matter has not been concluded or hasn't been re-enrolled, you're going to assist with that in today's evidence.
Indeed, so Honorable Chair, I made an attempt to place evidence before this committee explaining the delay as well as the 342 capital A, C reasons.
So just now, just to focus on your affidavit, we know now that you served as a senior state prosecutor for a long time in the NPA. You served in the organized crime unit, but since 1 September, you resigned, and we discussed the reasons why you do not disclose your current employment. Do you just want to give us some overview of your own professional background, which you reference at paragraphs 5 to 8 of your affidavit?
Indeed, so Honorable Chair, I commenced my employment with the NPA as a prosecutor on the 3rd day of April 2000 at the Magistrate Court, Taung. In 2002, I was promoted to become the Regional Court Prosecutor for the Regional Court in Taung, that is in Northwest. In March 2007, I was appointed as a State Advocate at the Office of the Director of Public Prosecutions in Kimberley, Northern Cape. There my duties are listed there in paragraph 5, which inter alia included dealing with high-profile matters like murder, robbery with aggravating circumstances, rape where victims were murdered. I also dealt with appeals and reviews. And then in 2009, I was appointed as Senior State Advocate at the Office of the DPP Kimberley. And in March 2010, I was transferred to the Office of the DPP Gauteng, Pretoria as a Senior State Advocate at General Prosecutions and subsequently at the Organized Crime Unit. And as a Senior State Advocate, my responsibility included dealing with high-profile matters and complex criminal cases. I also supervised junior advocates. During my employment in the Office of the DPP Gauteng, Pretoria, I was allocated serious cases of police corruption, racketeering, money laundering, cash in transit robberies, murders, taxi violence cases, and targeted assassinations and other cases of a similar nature.
Thank you. Then you describe at paragraph 9 the purpose of your submission to this honorable committee.
Indeed, so Honorable Chair. And I described there that the purpose of this affidavit is to make submissions to the ad hoc committee demonstrating that at a particular point in time, the Independent Police Investigative Directorate, which is IPID, was infiltrated by Mr. Paul O'Sullivan, who was a complainant in a matter that was allocated, that I was allocated to prosecute, as well as her assistant, Sarah Jean Trent.
Then at paragraph 10, you say this, what this matter really, or what's at the heart of this matter is the investigation by the IPID, and then the subsequent threats and intimidation and interference against you and the investigation team and by some of the witnesses, including O'Sullivan, McBride, and some other people. In your submission, you demonstrate interference against you, persons involving, including Mr. McBride. You make submissions about the steps, which is of concern to this honourable committee, that you undertook to re-enroll the case. You make submissions to this committee about the witnesses or some of the witnesses who testified already before this honourable committee, including O'Sullivan, McBride, General Pashlani, and other witnesses. You respond to allegations made by McBride and one Brigadier Tayani Shlungwani before this committee. And you address some of the related matters.
Indeed, so Chairperson. So in summary, my submissions regarding paragraph 10 will show or demonstrate evidence which will ultimately show that there was a considerable interference with the investigating officers, with me as a prosecutor, which would have contributed to the delay of the Camille Drift case 12/01/2070.
Okay. Then the aspects of your affidavit which follow the mandate of the NPA from paragraphs 11 through to paragraph 22, which is from pages 5 to 8, are more formal matters, the fundamental principles of that guide the prosecution of a matter under the NPA, and also your role as a prosecutor. Do you want to summarize some of that?
Yes, in summary, I would highlight paragraph 16, in terms of which Section 32, subsection 1A of the NPA Act states that a member of the NPA shall serve impartially and exercise, carry out, or perform his or her powers, duties, and functions in good faith, without fear, favor, or prejudice, and subject only to the Constitution and the law. And paragraph 17, section 32, 1B of the NPA Act, which provides that subject to the Constitution and this Act, no organ of state and no member of or employee of an organ of state nor any other person shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out, or performance of its or her or his powers, duties, and functions. Paragraph 18, section 41 of the NPA Act provides that offenses and under offenses and penalties, any person who contravenes the provisions of section 32(1)(b) shall be guilty of an offense and liable on conviction to a fine or to imprisonment for a period not exceeding 10 years or both such fine and imprisonment. And I state these paragraphs and provisions in light of what happened during the investigations of the case that I was guiding, and the threats and the interference and the hindering that was occasioned by some of the people involved or accused or suspected in that case.
And you have a comment at paragraph 21 about people like O'Sullivan, McBride, and others who label themselves or call themselves as corruption fighters. What's your opinion?
Yes, I do say that because I have been subjected to sustained interference, insults, and the allegations were that I was captured. In fact, during that time, there was a sustained attack which included interviews, O'Sullivan going to for interviews at different radio stations, Radio 702, Power FM, and at different articles were written about me, and ultimately my name even made it into a book by a certain Jack Paul, where allegations of state capture and corruption were made against me, just because I had made a decision to prosecute Mr. Paul O'Sullivan and some other suspects. As the committee will see later, there was more than sufficient evidence that I relied on to prosecute those people.
Okay. Then from paragraph 23 onwards, you deal with the nature of the matters dealt with in the organized crime unit to which you were assigned. And those clearly, I mean, it's apparent from paragraph 23.1 through to 23.3 that it deals with the most serious of matters. Because it is important to establish your credentials as a senior prosecutor and your views in this matter. Is there anything from under this section, paragraphs 23 to 28, that you want to underline before we move on?
From this, the only important paragraph that I would like to bring to the attention of the committee is the duty of the prosecutor in giving instructions after a matter has been opened, or a case docket has been opened by the police. They do some preliminary investigations, compile the docket, then they bring it to a prosecutor. From there, a prosecutor now starts giving out instructions as to which investigations he would like to be carried out. So
that's the prosecution guided approach.
Yes,
in matters of serious nature like this, also adopted by the PKTT and their team.
Yes, that is the prosecution guided approach, but not the prosecution led.
Is the prosecution led the IDAC approach?
Yes.
And you say there's a difference.
Yes. Indeed, so, Chairperson.
Okay. So, in other words, your involvement in the Camille Drift case, this particular case, was quite involved and quite intimate in terms of guiding the investigators and the prosecution of this matter.
Indeed, so after the investigators investigated the matter, collected a few statements, then the docket was taken to the DPP office for a decision. So at the DPP office, it is brought to the attention of the deputy in the DPP office, and then the deputy allocates it to a prosecutor. either a junior state advocate or a senior state advocate. And then by then, because organized crime unit dealt with very serious offenses of which are organized in nature, there were only senior state advocates there. There were no junior state advocates. So before me, there was a prosecutor or a senior state advocate who was advocate.
Mashuga, if you can just move closer to the microphone.
Thank you. Yes. Before me, there was a senior state advocate who was allocated the matter to deal with. So he, at some stage, resigned, and then I was selected to deal with this matter.
Okay. So we move on in your affidavit under the heading the mandate of IPID, and you reference IPID because this will, for you in your affidavit, illustrate or highlight the kind of interference by O'Sullivan, amongst others, in the affairs of IPID. So you set out the mandate of IPID with reference to the Constitution and the IPID Act. Do you want to highlight any particular paragraphs, perhaps 31, 33, and 35, yes. 36 and 37 of your affidavit?
Thank you. In fact, I would like to deal extensively with those paragraphs because it is actually the crux of the matter in terms of whether there's always been this question whether Mr. Paul O'Sullivan and Trent were entitled to involve themselves in this investigation, and whether IPID had abdicated its statutory power and duties and functions to a private person. So I would deal extensively. I would start with paragraph 30, which says that, 29, which says section 206, subsection 6 of the Constitution lays the foundation for the establishment of an independent police complaints body, which is to be established by national legislation. Paragraph 30, the Independent Police Investigative Directorate, 2011, Act 1 of 2011, which is referred to as IPID Act, establishes the IPID. Paragraph 31, Section 2, subsection D of the IPID Act provides for the object of this act, which inter alia are being to provide for independent, and I would like the committee to underline independent and impartial investigation of identified criminal offenses allegedly committed by members of the SAPS and municipal police services, because in this paragraph, I place evidence before this honorable committee that the IPID investigation at that stage was not independent because it was infiltrated by and led by Mr. O'Sullivan and Ms. Sarah Jane Trent, who were not only not independent and biased, but who had a motive to who had a motive had a motive to falsely implicate General Patlani, as we will see in the subsequent evidence that I deal with. And then also you will see that where the section says IPID had to deal with identified criminal offenses allegedly committed by members of the SAPS. Now they extended their own mandate now to include dealing with private citizens who were not members of law enforcement, and even a minister who they had no mandate to investigate him. And then in this affidavit, and I'm at paragraph 32, I demonstrate that the IPID, by permitting O'Sullivan and Trent to lead their investigation into the Patlani matter, runs contrary to the very independence and impartiality the IPID Act seeks to protect and guarantee. And then importantly, at paragraph section 25(1), importantly because it relates to the core of the charges that I preferred against the suspect. Section 25(1) of the IPID Act further provides that no member of the directorate may conduct an investigation in respect of a matter in which he or she has a financial or any other interest which might preclude him or her from exercising or performing his or her powers, duties, functions in an objective manner. So this section deals or refers to a situation where an investigator is related to a person and then involves that person in an IPID investigation, whether that person is related to that person as a friend or as a person who has at some stage helped him financially, or maybe where the person is related to him, where he's a wife to him. He cannot involve those people in an IPID investigation. And then section 25(2) provides that if during an investigation it appears to a member of the directorate that a matter concerns a financial or other interest of that member as referred to in subsection 1, that member must, 1, immediately and fully disclose the fact and nature of that interest to the executive director and withdraw from any further involvement in that investigation. We know that the IPID members, the Patlani task team, had these kind of relations with Sarah Jane Trent and O'Sullivan, where there were favors exchanged amongst and between themselves, the interest being to see General Patlani being removed as a national director or suspended. So the evidence is there. I will set it out during my affidavit and refer to real evidence. Section 33(2) provides that any member of the directorate who willfully discloses information in circumstances in which he or she knows or could reasonably be expected to know that such a disclosure will or may prejudicially affect the exercise or the performance by the directorate of the powers and functions is guilty of an offense. Section 33(4) provides that any member who fails to make a disclosure in accordance with section 25(2) or fails to withdraw in terms of section 25(2)(b), as the case may be, is guilty of an offense. Even the regulations, regulation 10.1 of the regulations for the operation of the Independent Police Investigative Directorate provides that all information, whether verbal or in writing, and all documentation acquired during the course of an investigation conducted in terms of the Act and all records pertaining to any such investigations are to be treated as confidential and may not be divulged to any person outside of the Directorate unless authorized to be divulged in the interest of justice by the Executive Director or relevant provincial head, as the case may be, in writing or an Act of Parliament. Now, several of the charges against the IPID members related to this contravention of section 33.
And yes, you conclude at paragraph 38 that your submission is that the accused and the suspects in that case have all contravened these provisions that you referred to.
Indeed so, Chairperson. Now, I also highlight at paragraph 31 the prevention, the definition of the Prevention and Combating of Corrupt Activities Act.
31 or 39?
39, oh, sorry, Chair, 39. And then section 1 of the Prevention and Combating of Corrupt Activities Act, number 12 of 2004, provides the definition of gratification to include money, whether in cash or otherwise, any donation, gift, or loan, any forbearance to demand any money or money's worth or valuable thing, any other service or favor or advantage of any description, including protection from any action or proceedings of a disciplinary, civil, or criminal nature. We have heard before this honorable committee that Mr. O'Sullivan admittedly made a contribution of 200,000. I think he said 200,000 for the legal expenses of Mr. McBride, and that was during the period that Mr. McBride was suspended. So immediately thereafter, in November, Mr. McBride was reinstated. Same time, O'Sullivan now approaches Mr. McBride and then involves himself in the investigations against the General Patlani. Now, that definition, which says including protection from any action or proceedings and forbearance to demand. So it demonstrates to us that he paid that money for the legal expenses of Mr. McBride as a forbearance for him now being involved in the investigation and exercising the functions and powers of IPID.
So that amounts to gratification.
That amounts to gratification in terms of the Act. And then I deal with the other contentious issue of the National Credit Act. Mr. McBride and Mr. O'Sullivan said there's nothing wrong with a person accessing the credit information of private citizens. In fact, that is a very, very dangerous contention by them. So I deal with the National Credit Act 34 and under section 68(1 provision is made there that any person who, in terms of this act, receives, compiles, retains, or reports any confidential information pertaining to a consumer or prospective consumer must protect the confidentiality of that information, and in particular must use that information only for a purpose permitted or required in terms of this act, other national legislation, or applicable provincial legislation, and report or release that information only to the consumer or prospective consumer or to another person to the extent permitted or required by this act, other national legislation, or applicable provincial legislation, or as directed by the instruction of the consumer or prospective consumer or an order of a court or tribunal. Now, the regulation 18.4 of the National Credit Act regulations as amended by the 2015 regulations provides that the prescribed purposes other than for purposes contemplated in the Act for which a report may be issued in terms of Section 70, subsection 2G, are inter alia. One, an investigation into fraud, corruption, or theft, provided that the South African Police Service or any other statutory enforcement agency conducts such an investigation. Two, fraud detection or fraud prevention services. Now, I'm stating this fact because we know from the information, and when we were even able to obtain a statement from TransUnion as to the reason why O'Sullivan and Trent accessed the credit reports of private people. Now, we know that they used this 42.2 reason, fraud detection or fraud prevention, but they cannot, they are liable in terms of the of the contravention of the Act because there was no complaint of fraud made to them in the first place. Secondly, other than that, there was no fraud and detection. We know that the witnesses whose credit reports were accessed were not suspects. In fact, the witnesses were state witnesses in their own, in IPID's own investigation. So why did they have to investigate their own state witnesses? And then finally, I referred in paragraph 43 to section 86(1) of the Electronic Communications and Transactions Act, and it relates to also the accessing of the credit information, which says subject to the Interception and Monitoring Prohibition Act 1992, a person who intentionally accesses or intercepts any data without authority or permission to do so is guilty of an offense. This section, Honorable Chairperson, has now been amended, actually deleted, because of the promulgation of the Cybercrimes Act 19 of 2020. So there's provision for this offense now in the Cybercrimes Act.
Then in conclusion on this section, you underscore the points that you make with reference to that SCA case at paragraphs 44 and 45.
Indeed, so Chairperson, in that case, I refer to it where it says, and I quote, "The second issue concerns the undesirable fusion of private and police investigations. It appears from the evidence referred to earlier that AIN commanded the resources of the SAPS when it saw fit. The police officials involved readily complied. The SAPS is not up for privatization nor for direction by parties such as AIN. This too is a matter that should be dealt with by the relevant authorities. And on my paragraph 45, lastly, it is not only that the lines between the AIN and police investigations became blurred, but as set out above, police officials acted in two capacities, even going to the extent of doing AIN work whilst on police sick leave. This is untenable and should be investigated by the relevant ministry. So at paragraph 46, I state that I implore this honorable committee to keep all this legal basis, the contravention or rather the provisions of the IPID Act, this case, the National Credit Act. I implore this honorable committee to keep this in mind when we go through the contraventions or the offenses that were preferred against the accused.
Okay, thank you. So now we get to your involvement in the Camille Drift matter from paragraph 47 onwards. Describe how you came to be allocated the matter in February 2017.
Indeed, so Chairperson, the Camille Drift matter was initially allocated to a certain state advocate who later resigned. And then in February 2017, the matter was allocated to me by the Deputy Director of Public Prosecutions in the Organized Crime Unit, after a request was made to the DPP himself to assist in securing an advocate due to the commitment of advocates from the Organized Crime Unit. So in the Organized Crime Unit, they normally deal with matters which are more serious, and they take time to study and take through the trial process. So most of the time, you will find that they are all committed, and then they would request that an advocate from outside organized crime be provided. So that is how I was then requested to deal with this docket.
And then at paragraph, once you received the docket, what was your first task?
Yeah, my task was to establish from the contents of the docket whether there is any evidence of the commission of a crime, which is the normal task which prosecutors do when they receive a docket. And secondly, if there is a need for further investigations, in which case then to guide such investigations. As I explained before, as soon as the prosecutor receives a docket, he studies it, he identifies whether there's a need for further investigations, and and then guide such further investigations.
And then at paragraph 50, you highlight the offences which you had identified that the suspects would have contravened at paragraph 50 after you studied the docket.
Indeed, so Chairperson, I identified that there was intimidation, and the intimidation was the one regarding General Patlane, where he was told that he will be imprisoned, his house will be sold at an auction by O'Sullivan, and he would sell it at, he would buy it at an auction and sell it just like he did with the house of Kretcher. That is what he said. And then also extortion against General Patlani. Then there was this contravention of Section 33(5) of the IPID Act, where they presented themselves and acted like IPID investigators, and a conspiracy to commit this offense, and that relates to the two IPID officers who, despite O'Sullivan and Trent acting and pretending like IPID officers, obtaining statements of witnesses like IPID officers, and all what they did. The two IPID investigators did not stop them, or so they allowed them to continue contravening the IPID Act. So they were, I preferred the charges of conspiracy against all of them. And then there's also fraud, where they pretended to Chris Joste, the estate manager, that they are IPID investigators, and they are entitled, using the power of IPID, to access the confidential house plans of General Patlani. So that misrepresentation, I preferred the charges of fraud. And then the extortion of Chris Joste, where they intimidated Chris Joste when he did not want to give them access to the house plans. They intimidated him and said he will be sentenced to 2 years imprisonment. But we know that the 2 years imprisonment was if a person does not cooperate with IPID investigators, not private persons like Paul O'Sullivan and Sarah Jane Trent. And we know that after those house plans were provided by Chris Joste, it is O'Sullivan who took pictures with his phone of the house plans. So in fact, it was O'Sullivan's own private investigation, not an IPID investigation, and they were just using IPID officers as cover. We know that the intention was to show General Patlani that I told you that I'm going to take you to prison. Now here I'm taking you to prison. Because one other factor in this case is that when these investigations were going on, when O'Sullivan and Trent were obtaining this information of the investigations by IPID, they continued taunting General Patlani, sending emails to him that I told you I'm gonna do this and this, and now here you are. And then, the attempted extortion is against General Patlani, where all these threats were made to him, but obviously he did not succumb to be part of the cabal of O'Sullivan and Trent. So the threats did not result in anything. So there was no advantage in terms of the definitions of extortion that was gained.
So you after you considered the totality of the evidence, you identified O'Sullivan, Trent, Tamani, Binang, Mandla Kaisi, Mashlangu, who's late. You identified them as suspects in relation to these charges, and that you describe at paragraph 52.
Yes, in summary, that is the position, Chairperson.
Okay. From paragraph 55 onwards, you discuss the background to your submissions, and in relation to this Honourable Committee's terms of reference at 56.2, paragraph 56.2, to establish whether any wrongdoing, corruption, or breaches of conduct have occurred within SAPS or any other relevant institution as outlined in the regulations. So that's in summary the context in which you are giving this evidence.
Indeed, so, Chairperson.
Then I think we've discussed this. I don't think you need to spend much time. The Honourable Committee members have also read your statement. The process of prosecutorial decision-making from paragraph 59, the whole of 59 through to 61. You conclude at paragraph 60, I can confidently state that I applied myself to the obligation set out above, consistently but more particularly in my handling of the docket in a cumulative matter.
Indeed, so, Chairperson.
Okay. Then you have summarized the charges preferred and the relevant evidence, summary of the facts, which you deal with from after paragraph 61, 62 onwards. Is there anything you want to highlight there?
In fact, Honourable Chairperson, I have already summarized this, so I don't need.
Okay.
I don't think there is a need to repeat it.
Okay. Yeah, just again for ease of reference, the charges of intimidation from paragraph 67, the charge of contravention of 33.5, the IPID Act, and conspiracy to commit such an offence. That's at paragraph 68. Fraud at 69, extortion at paragraph 70, attempted extortion from paragraph 71, contravention of section 18B, small Roman 5 of the of PRECA.
That one I would like to
yes, please
give light on, because indeed this offence, as I say at paragraph 78, this offence is based on evidence of Jooste when on 17 November 2016, O'Sullivan induced Jooste to sign a statement containing false information, and this offence is based on evidence also of Antoinette Wilhelmina Venter, when on 17 November 2016, O'Sullivan induced Venter to sign a statement containing false information. So what happened in this, in the offences referred to in these two paragraphs was that O'Sullivan, whom we knew that he was a private person and not an IPID member, he drafted statements for the two witnesses, that is Chris Jooste and Antoinette Venter, and then he emailed them saying that this is their statements. And Jooste says in his witness statement that Mr. O'Sullivan did not even interview him relating to that statement. And Antoinette Fenter also says that she was not interviewed. That is why when they received that statement, which said that it was couched in a language that seemed that it is just an innocent draft that demanded that the witness can just look at the statement and amend where possible. But we knew that it was in contravention of the law because, firstly, they were not IPID officers. They had no business with drafting witnesses for witnesses who are IPID witnesses. Secondly, we knew that they acted with intention because there is that issue where they had threatened General Patlane that we are going to imprison you, we are going to take you to prison. And we knew that that was part of them taking Patlane to prison. We knew that before these statements were sent to witnesses, there was intimidation, according to Chris Joste. He was intimidated. So O'Sullivan, the inferences that can be made is that Mr. O'Sullivan, after intimidating Joste, knew that he would cooperate to anything that he wanted. And then on paragraph 81 or 80, this offense is based on evidence of Joste when on 18 November 2016, O'Sullivan induced Joste to sign paragraph 81. This offense is based on Annex MM4 Commission, which is attached as MM4, when on 23 November 2016, Trent induced Joste to withhold information from a police docket. So Trent sent a WhatsApp, and I will read it from MM4.
And give us the page. It is paginated.
Yeah, it's MM4, annexure MM4.
Yeah, but the page reference. I think it's 66. Yeah.
Yes, it reads, Hi Chris, please send me your name and ID number as appears on your ID for the subpoena. Thanks a million. Already we know that these are private persons, not IPID officers. They do not have any business to subpoena witnesses. Secondly, hi Chris, we are on our way to your offices. Officer Mandla says the CCTV photos are not important and can be removed from the statement. Now, Section 18, subsection B(v) of the Prevention of Corrupt Activities Act (PRECA) makes it an offense for a witness or any person to persuade, and persuade is defined there as including cause a witness to remove any part of his statement. This is exactly what Trent was doing. she was instructing, or we can even say requesting a witness to remove a paragraph which dealt with CCTV photos. She had no right to do that. She had no right to interfere there. And in my view, this contravened Section 18BV of PRECA.
Okay, please pause a little, SC. Someone.
Thank you very much. SC, I'm sorry for interrupting. Please do guide us, because this paragraph keeps, these paragraphs keep referring to false information. Are you going to delve into what this false information is? Because it's making it difficult for us to follow. Thanks.
Yes.
Sorry, Honorable Acting Chair. Perhaps if we could direct that question at the witness. The affidavit is quite detailed in that regard. Advocate Mashuga, do you want the question to be repeated?
Yes, please.
Okay, thank you for that guidance through you, Chair. On paragraph 78, I think 78, 79, and 80, you indicate that I think it's Ms. Trent, Mr. O'Sullivan were inducing the witnesses, Mr. Euster and Ms. Venter, to produce false information. What is the false information?
This false information that was contained in that statement was, maybe I should just give a brief background. After the visit to General Patlani's estate, one of the witnesses called General Patlani and told him that there were some people who said they are from IPID. They were looking for my bank statements, and they were asking questions about your house. Then General Patlani called the estate, I think it's Chris Joste, and the manager, and asked him whether there were people who had come there looking for his confidential private information. And Joste agreed. And then he said, but you must not give people like O'Sullivan my confidential information. And then General Patlani sent, because Chris Joste forwarded a picture of O'Sullivan's motor vehicle when they were at the estate to General Patlani. General Patlani forwarded that photo to McBride and said to Mr. McBride, I was informed that a private person was accompanying IPID investigators to the estate. Here is the photo of the car. Ethical investigations are encouraged. After receiving that, it would appear that Mr. McBride then sent the information to Paul O'Sullivan. That is the reason why Paul O'Sullivan made these statements. That is the reason why a case of defeating the ends of justice was opened against the General Patlani. So the false allegations there were those that were contained in that statement, which said that General Patlani encouraged the witnesses not to cooperate with IPID investigators.
You deal with it at paragraph 85. Defeating the course of justice.
Indeed so, Chairperson.
I think you can also add The question is mostly based on the further preferred charges against Trent, O'Sullivan, and Mahlangu, where they are alleged to have forced Juste and other witnesses to make false information about the operation of O'Sullivan and the company. So I think the specific question that comes from Honorable Sangon is that what kind of information were they forced to make? What is it that they were told to say about Pahlane or the operation at the estate?
No, this specific charge relates to the statement, the draft statement that was made by Mr. O'Sullivan after McBride informed him, and there we are relying on inference that he would have been informed by Mr. McBride that Pahlane knows what we did, what we were doing at the estate. So O'Sullivan then drafted these two statements for Antoinette Velemina and Chris Juste. And what is important here is that he never even talked to Antoinette Velemina about those allegations. He just drafted a statement and sent it because he knew that he had already intimidated them, especially Chris Juste, on the previous occasion. So he knew that they would comply with his request that they admit that those allegations are true.
Also, this.
May I continue, Chair? Thank you. Thank you, Advocate Mashuga. Perhaps just if highlight or reference some of the paragraphs in your affidavit in relation to crime and injuria at paragraph 87, the charge of perjury at paragraph 89, the personal information illegally accessed and used to what you describe or is quoted as dig up dirt about adversaries at paragraph 93.
Chair, I refer there to Exhibit MM6. It contains of 3 pages. In fact, 4. So, at some stage during the investigations, General Pahlane made an application for the interdict against the IPID, Paul O'Sullivan, Sarah Jane Trent, and they had to file answering affidavits. Now, in those answering affidavits, they made certain false allegations. In fact, there was an answering affidavit and confirmatory affidavits by the others. So the person who answered was Mandla, and the others like O'Sullivan, McBride, and the others just confirmed. So,
and the annexure you referred to is MM6?
Yes, it's
and that's from pages 68 to 71, and the selected paragraphs in the answering affidavits.
Yes.
One finds from paragraphs from page 69 through to 71.
Yes. Now, MM6 stays there in paragraphs in page 73, paragraph 217. There is no blanket restriction against O'Sullivan. However, if he was not involved in the investigation of Patlane. He merely assisted in the preliminary stages by locating certain witnesses who could corroborate the allegations against him. But we knew that this is wrong and this is false allegations that they are, or false information that they are including in a sworn statement. That is one of the reasons that we charge them with a perjury. And also in paragraph 234 of the same affidavit, I also reference it there. It says, I note and confirm that O'Sullivan has indicated that he is not involved in the investigation process undertaken by IPID. I mean, by now, we all know that O'Sullivan was deeply involved in the investigation process undertaken by IPID. Also at page 57, paragraph 148, I confirm that from around 25 November 2016, O'Sullivan had no involvement in the investigation. We know, even from the downloads, that O'Sullivan and Sarah Jane Trent were involved in the investigation up until the 7th of February 2017, 3 days before Sarah Jane Trent was arrested.
Now, this application brought by General Paslani, that was not concluded. That didn't go through its conclusion, didn't go through the court.
I do not know where it ended up, Chairperson.
Okay. In fact, after this application was launched, they were arrested, brought to court. Or rather, Trent, I think, was arrested, and O'Sullivan was summoned. The other two were summoned to come to court. I'm not sure whether.
Yes, I'm not sure. I will find out. But Trent was arrested on the 10th of February 2017.
Yes. I'm not sure if it's apparent from this. I'm looking at M6, the notice, the filing notice, that the date of the issuing of these papers doesn't appear.
It does not appear, but during break, I will give you all the information.
Then paragraph 93, personal information illegally accessed and used to dig up dirt about adversaries. You want to, at paragraph 93, you want to mention or refer to those paragraphs?
Yes, paragraph 93, where I refer to when Trent was arrested, a cell phone was seized in terms of section 23(1)(a) of the Criminal Procedure Act, which provides that, I quote, on the arrest of any person, the person making the arrest may, if he is a peace officer, search the person arrested and seize any article referred to in section 20, which is found in possession of or in the custody or under the control of the person arrested. So this is commonly referred to as a warrantless arrest, because normally a search and seizure is done in terms of Section 21 of the Criminal Procedure Act, where a normal search warrant is applied for to search and seize and download the information. But now there are two provisions: the one that those that are referred to as warrantless, and Section 23(1)(a) is one of the warrantless search and seizure of a cell phone. And at 94, the cell phone was booked into the SAPS 13 and handed to the cybercrime unit for downloading. I was later informed by the investigating team that the cell phone was successfully downloaded, and I was provided with the downloads. In 95, what was found in the download is quite shocking when one considers the fact that McBride and O'Sullivan labeled themselves as corruption fighters. And I indicate there that I do not list the contents of the download of Trent's phone in order to preserve the integrity of the evidence, taking into account the undertaking made by the NDPP to the chairperson that the decision to delay the enrollment of the case is to be reconsidered. I only refer to the content of the download, which serves as evidence of criminal conduct, and those which I referred to, or the facts which I referred to under the charges that I preferred against Trent and others in the draft indictment. And I may add that also a prosecution, draft prosecution memorandum. In 97, I say the following are examples of the types of activities identified in the cell phone. 97.1, there were discussions about Patlani's arrest. 97.2, the inquiry by Trent, who directed to Matlangu regarding the success of the operation at Patlani's place. Now, in this regard, there was a search warrant. I think I followed Nkabinde's evidence before this committee, where he said they applied and obtained a search warrant to go and search General Patlani's house, but the intention was not to actually confirm the sound system, but it was to confirm what was inside the house. So after the search, Trent and Matlangu did discuss about the success of the operation at Patlani's place. Before the search commenced, McBride leaked the search to the press. In a communication with Trent, Trent asked McBride, who leaked the information to the press, to which McBride replied that it was him. Similarly, after the search was concluded, communication between Trent and Mandla Matlangu showed that they in fact misrepresented to the magistrate that they are going to search for the sound system. They were actually searching the whole house. That's what they said, that they searched the whole house. And that was with the intention of identifying inter alia the air cons inside the house, the finishes inside the house, to provide to O'Sullivan. And then Mandla even asked Trent, how is Paul taking it? Then Trent said, she's taking it brilliantly. He's even on his way to get a Guinness. So a Guinness is some kind of a beer. So that is the disregard of a person's privacy that they were prepared to go to lengths to violate. Then at paragraph 97.4, I set out that Patrick Johnson causing problems for Mr. McBride on the Marcosin matter. So McBride sent an ID number to Sarah Jane Trent and requested Sarah Jane Trent to get the credit record of Patrick Johnson, because Patrick Johnson was the one who was causing problems for McBride on the Marcosin matter. So there was apparently a case against McBride where the witness was Patrick Johnson. So they wanted to deal with him. And then they continued that his false matric certificate must be exposed, and suggest that rather Sarah Jane Trent and Paul tip off on the guy than McBride, because it's going to be seen as revenge if McBride tips off. And then I note there that Marco Singh was a witness against McBride in a certain case. And I note there that this is exactly gratification in terms of the precca, because there was what we call a quid pro quo, value for value. So there was this issue of IPID helping or assisting Trent and Paul O'Sullivan to get back at General Patlani in order to have him not or suspended or dismissed. On the other hand, McBride now was getting all these favors. These problems with people like Patrick Johnson were resolved. So this is corruption within the meaning of Precca. 97.5, Nhleko trying to get rid of me again. There was a discussion of a counter-attack when Minister Nhleko tried to reinstate the case against Mr. McBride. So this also constitutes a gratification, because there was plans of a counter-attack. Minister Nhleko's information was accessed by Sarah Jane Trent, and then there was a report on the media that they leaked, which said 30 million rand Nhleko house, alleging that Minister Nhleko had built a house to the value of 30 million rand. And I note there that this is also a gratification, as there is quid pro quo, value for value. And then the other gratification was of McBride regarding a polygraph test which was arranged and paid for by O'Sullivan. Now, in this regard, there was a meeting which Nkabinde referred to on the 3rd day of December 2016. This meeting, Nkabinde attended.
Is that the one at Kretsch's house?
Yes, the one at Kretsch's house. After the meeting, I think about a week thereafter, the meeting was leaked to General Mokotedi. Now, General Mokotedi opened a treason amongst others, a docket. So when they heard about this from the media, they started to panic. I'm saying this in light of the fact that it was said here before this honorable committee that the meeting was about a bribe, then later a meeting was about the launch of a book. I mean, if it is an innocent meeting, why do you have to panic and said you are going to counter the allegations by Mokotedi, and then they devised a plan in which to say that McBride and Mokotedi must go for a polygraph test. But before going to the polygraph test, they invited, rather they arranged that Paul O'Sullivan is the one who is going to provide questions to be asked at the said polygraph test. Fortunately, General Mokotedi withdrew from that polygraph test. But here I'm saying that this also constitutes gratification, because other than McBride being gratified by this arrangement, arrangement of a fake polygraph test, other than that, Trent and O'Sullivan are the ones who paid for this polygraph test. And we have invoices in the docket. We have a bank statement that showed that they are the ones who paid on behalf of McBride. And then 97.7, I deal with several instances where Trent was compiling Section 205 requests and receiving the information from IPID members when it was provided by banks and cell phone network providers, despite her not being a member of IPID, which is a contravention of the provisions of the IPID Act. I also refer in 97.8 of several instances where Trent and O'Sullivan accessed credit bureau records of several people, including witnesses against General Patlani. In some of these witnesses, she is requested by Mr. McBride to do that. On one instance, McBride leaks an ID number of Alvin Dupree. Alvin Dupree was Patlani's driver and a witness in their matter. So he leaks an ID of Alvin Dupree to Trent and instructs her to find anything strange on his credit record, which may suggest that he doesn't require. The reason for that, they wanted Alvin Dupree to confirm a draft statement which implicated General Patlani. So Alvin was refusing to confirm that. He said, no, that is false. It must first be amended. So that is why now they wanted to get his credit report, probably in order to have leverage against him. And I note there that IPID had no mandate to investigate private citizens, even a minister. And paragraphs 97.9, I refer to the legislation dealing with the accessing of credit bureau information. And Chairperson, I have already dealt with this before, the national provisions of the National Credit Act.
So just while we pause there, you also deposed to substantially the same matter before the Zondo Commission of Inquiry.
Yes.
You also deposed to a lengthy affidavit,
Yes.
which contains substantially the same allegations, submissions. And we also know that Mr. O'Sullivan had also deposed to an affidavit to the Zondo Commission,
Yes.
Essentially contesting your submissions, your allegations.
Yes, what happened is that at the commission, there was a provision that the affidavits by the witnesses must not be supplied to any other person. So we had to send them to the commission. Now, O'Sullivan, when he made his affidavit, he does not only send it to the commission, he sent it also to me because it contained insults and threats and all those things. So he wanted me to know what he's saying to the commission.
In fact, your affidavit was only released to this committee upon application to the NPA to release your Zondo affidavit and the annexes to us.
Yes, it was released because the Honorable Chairperson wrote a letter to the Department of Justice requesting that they release that to me. They could only release it to me because of the confidentiality consideration.
Okay. Then perhaps if we could just perhaps fast forward to at paragraph 106, you start dealing with the plethora, what you call the plethora of threatening and insulting emails from O'Sullivan, which you regard as interference. You want to highlight some of them?
Indeed, so, Honorable Chairperson, in an email dated 4 November 2017, a copy of which is marked as Annexure MM7, where O'Sullivan stated, amongst others, not Flock, Mlocha, Mabula, Korani, Ngube, Mashuga, or any of the scum out there can survive what is coming. Good will triumph over evil. It always does. Then in an email addressed to me dated 4 November 2017, copied to several people, O'Sullivan inter alia accused me of having meeting with criminals and that I and the Northwest crooks are all guilty of theft of Sarah Jane's phone, unlawfully sending it to Israel. Andres brought it back last Friday and was seen at the airport by one of my people and unlawfully downloading the contents, not only a breach of a constitutional right since there was no such warrant in the first place. Yes, this is also a breach of Act 70, which carries a 10-year sentence. A copy thereof is marked, is attached as MM8.
Yeah, that's at page 74 of the paginated papers, M8. M9 you have now provided because it was missing from the statement and the annexes printed yesterday.
Yes, in fact, it was provided today after we were informed that it was missing, but I will provide it.
Yeah, you did.
I will ask copies to be made there.
Okay.
And in an email addressed to Mzinyati is the DPP, dated 15 November 2017, he states, the latest criminal suspect I need to bring to your attention is Advocate Mashuga. The copy thereof, marked as Annexure MM9, is attached. And then in two emails addressed to me on 30 November 2017, one of which was addressed in the early hours of the morning at 1 a.m. He inter alia refers to me as a criminal that broadcast for the Patlani family, being dishonest, protecting criminals and being rubbish. In particular, he indicates that he himself will deal with me. And in the second email, he states as follows, people that protect criminals like this are the lowest form of criminals. In fact, he was not referring to me where he said criminal that bought cars for Patlani. I think he was referring to one of the suppliers. And then emails from O'Sullivan to me on 6 December 2017. In the email at 14:02 p.m., he states, "Hey, you dishonest prosecutor, why don't you lock these two crooks up?" And the photograph of Ntleko and Patlani was inserted. "I'm closing in on all of you. You will rot in jail." So the list goes on and on. But what I want to draw to this committee, what I want to draw to the attention of this.
No, I'm just saying that you will rot in jail.
Indeed, so.
Is a phrase familiar with this? Ngabinde, when he was here appearing before us, he also showed us a message with that phrase, "You will rot in jail."
Yes, indeed, so. But now the issue here is that conduct of his, first of all, constituted contravention of Section 32. 1B of the NPA Act, which prohibited anyone from hindering or interfering or threatening a prosecutor. And also it constituted extortion because remember, I was prosecuting him. So his email were to the effect that because you are prosecuting me, then I'm going. There's one which said that he has gone to Northwest to dig information about me in Northwest, and what he's getting is concerning or something like that. So this is extortion. You are saying just because the prosecutor is prosecuting me, I am doing a revenge by investigating him. That is exactly extortion.
So, Mr. Mashuga, the whole trail of emails and insults that you describe continues throughout the whole of paragraph 106. And you also conclude at paragraph 107. Similarly, Pashlani was subjected to a plethora of threatening, insulting, demeaning, and intimidating emails from O'Sullivan. Such is dealt with in this affidavit to demonstrate the kind of character O'Sullivan is, and yet officials of an institution that is supposed to be independent and impartial. That's a reference to IPID.
Yes, indeed.
Allowed such a person to actively participate in the investigation against Pashlani.
Indeed, that is the submission I make.
Can we move on to the next topic?
Indeed, so.
Chairperson, can I ask for a short comfort break? 2 minutes. A short comfort break.
Time is it now?
It's 12:37.
Live. Onan. As I'm checking, it's just 20 minutes before 1. Are we unable to push before 1 and break at 1? We can allow you to go out and come back without, if you really want to go out. If you want to go out with the witness, you can call him.
No, I don't want to go out with the witness. I just wanted to move on to the. I'll be 2 minutes.
Yeah.
Thank you.
Yeah, let's check something.
Chair, we respect the elderly.
That's exactly what I'm saying. That we can't be asking him many questions. Yeah. Skosana.
Yeah. I just saw something.
You will rot in jail.
Yeah, I just saw something because the evidence leader is not around.
Yep.
I'm taking the page 79, which he was talking about here. The more I deal with low lives, dishonest people like you, the more I love my dogs. Okay.
Did you pay your debts?
I'm sorry?
Did you pay your debts?
Wait for tomorrow. Wait for tomorrow. You'll see sparkles fly. When somebody's lying before this committee, you will suffer the consequences.
So, but you're not a witness before this committee.
No, but he must answer. Remember, tomorrow I'll give you the proof of payment.
Honorable
Thank you.
No, Chair, I'm just taking advantage of the break. I didn't want to interrupt. If maybe African Mashuga, that polygraph test, what was it about? I keep hearing this thing that they paid for a polygraph. Why was Mr. McBride taking a polygraph test?
In fact, it's connected to the meeting of the third. So where invitees like Mandla Matlangu, McBride, Nkabinde, Cedric Nkabinde, all those people that were invited there. There was a certain Angelique Serrao or something like that. She was a journalist. Also, Mr. General Sibia was invited. So the invite said, Bry, 3 o'clock p.m., Bedford View. Then they gave the address, then top secret. It was listed as top secret. I'm saying this to say that if it was just a launch of a book, I mean, there's no reason for it to be top secret. Or if it was a bribe, there's no reason for it to be top secret. And then secondly, I'm saying that if it was an innocent bribe or launch of a book, why would they be so concerned about it when there was a leak about that meeting? So it corroborates the version of Cedric Nkabinde that actually that was a planning meeting where they planned to take over the criminal justice system by having, for instance, the removal of General Patlan. So after that, the discovery or the leaking of that meeting, they came with a plan. O'Sullivan and McBride and Trent came with a plan that they must refer the matter for a polygraph test to show who is telling the truth between Mukotedi and McBride. So that is when they arranged, they made pre-arrangement that O'Sullivan will provide questions so that McBride can go there knowing the questions already, and then Mukotedi would be disadvantaged. And then media must be invited to that so that everything should seem to be above board. So the invoice to the polygrapher was paid by Trent and Paul O'Sullivan. We have a statement of the polygrapher in the docket. We have proof of an invoice and a bank statement which showed this, and we submit. Rather, I must say, we preferred those charges in the draft indictment of corruption in contravention of section 3 and 4 of PREC.
Yeah, thanks, Chair. I suppose then it was just their own polygraph. Thank you, Chair. Through you, Advocate, we were respecting your break. I was just curious about who demanded a polygraph. How did we get to polygraph? Thank you.
May I proceed, Honorable Chair?
Thank you. Thank you for the.
You are allowed.
I'll be right for the next derby. Advocate Mashuga, you then in the next section that we're dealing with, although you've dealt with it quite extensively already, you allege the capturing of IPID by O'Sullivan and Trent. If you want to, you reference that by the evidence at paragraph 111 or 111. The evidence clearly demonstrates that Trent and O'Sullivan even went to the extent of preparing Section 205 subpoenas and statements which were presented as if they were compiled by IPID officials. Such conduct was embraced by the late Mashlangu and Binang, which is clearly wrongful, unlawful, and unprofessional conduct. And you describe that conduct as highly irregular and unlawful. Do you want to make any further comments on that section?
Indeed, so, Honorable Chairperson, here we are referring to, again, to the contravention of the IPID Act, where Trent and O'Sullivan were allowed by IPID to use powers which belonged to members of IPID, not to the private citizens. The main concern that we had whilst we were going through this investigation was, how does IPID disclose or allow a private citizen to access information that is supposed to be confidential, whilst that private citizen is, unlike IPID members, not subjected to a vetting exercise? What if that person is a threat to the security of the state, and then they are allowing that person to exercise the policing powers and exercise people's bank statements, people's cell phone records? That was the main concern, and that is why I make this submission at paragraph 111.
So if we come to the matter itself, we know now that the matter was removed from the roll.
Indeed, so.
Yes. And you obviously protested that it shouldn't, and the magistrate nevertheless ordered the removal of the matter.
Yes, I did indicate, I think that the matter had only started in February, and 8 November, it was struck off the roll. We were initially prepared to proceed with the matter, but then came the downloads, and the downloads now forced us to do some investigations and identify and obtain warning statements from more or additional suspects. Now, one of the things that was raised previously by Mr. Paul O'Sullivan and Mr. McBride was why did we effect an arrest before we finalize investigations? But the question, we answered it very simply. The nature of the charges and the conduct, criminal conduct that was being perpetuated by Trent and O'Sullivan required us to act immediately. Because if a person is going on intimidating witnesses, then there's a need to urgently deal with that situation. That is why upon information that he is intimidating witnesses, we had to deal with the agency that was required even before the investigations were completed.
So on at paragraph 116, which is on page 51, on the 8th of June 2017, you were approached by one Mansa Rapesu, is it how do you pronounce it, Rapesu?
Yes.
An IPID investigator who was part of the Patlani task team. He was instructed to obtain a statement from you regarding inter alia why you signed the warrant of arrest to the accused. That statement that you made is at triple M 14. Do you want to comment on that at all?
Yes, Chairperson.
Triple M 14
Yes.
is at, I think it's page 80. It's at 86. It's at page 86.
Yes. This statement, Rapesu, who was one of the Patlani task team, was instructed by the DPP office to go and obtain an investigation statement, from me as a result or pursuant to a case docket that was opened by Sarah Jane Trent and O'Sullivan, where it was alleged that where she was alleging that her cell phone was stolen and she was kidnapped. And we knew that the cell phone was obtained in terms of section 23, subsection 1A of the Criminal Procedure Act. And we knew that she was detained in the cells. So, however, the persons dealing with the advocates who dealt with the matter instructed that Rapesu must obtain a statement from me, and the questions which they asked and they wanted to be addressed were, number one, who is the prosecutor who signed the warrant of arrest? But it was already known in my office that I'm the one who was dealing with that case. I'm the one who signed the warrant of arrest. An affidavit must be obtained from him wherein he states why he signed the warrant. And I'm saying here that this is internally, this could have been resolved internally because we are in the same office. They could have just come to me and asked me, did you sign the warrant? Why did you sign the warrant? I would have given them the docket to say, go and read the docket. Was a docket presented to him? If not, was any information relayed to him? If so, what information? I mean, this is all information that they could have easily obtained from me rather than creating a situation where a DPP office, because at the DPP, we issue correspondence to external parties in the name of the DPP. So even if something is signed by a deputy director, we issue it in the name of the DPP. So now a situation was created where a DPP was telling a third party to come to the DPP and obtain a statement from the DPP or information from the DPP, which could have been easily resolved. But I made that statement. It's there in MM14. I didn't want to cause some consternation or
Yeah, you were requested to make another statement at MM15.
Indeed so.
Which is at page 92. But wasn't that pursuant to, you also attached, it's at the back of MM15 on page 94. This is now in relation to those two charges that were brought, or these cases that were instituted by Trent.
Yes.
The Santon case and the Littleton case.
Yes.
The abduction, assault, removal of the kidnapping. So on the 20th of June 2017, is this why Masha it's addressed to the IPID, R. Mansa, decision on the two dockets, Santon case number, that Littleton case number, your memorandum dated 24 April 2017. The Director of Public Prosecutions remarks as follows: the following must be done, obtained. Advocate Mashuga states in his affidavit that there was an interdict against Mr. O'Sullivan. A copy of this interdict must be obtained and filed in the docket. 1.2, a supplementary affidavit must be obtained from Advocate Mashuga, wherein he states if he was aware when he signed the warrant of the court order, a Littleton case number, kindly return the case dockets together with the requested information.
Yes. So in this one, in this regard, Chairperson, I did reply to them that the interdict that I'm referring to is an interdict where the applicant was Mr. Neil Diamond, and Mr. Neil Diamond had instituted this application against Mr. O'Sullivan for similar matters, which are intimidation and attempted extortion. So we were using that case to oppose the release of Mr. O'Sullivan on bail. So that is why I was requested to provide the copy of that interdict. In terms of clarifying if I was aware of the court order when I signed the warrant, is that court order which said that Mr. Paul O'Sullivan must be given 48-hour notice before he's arrested.
Is that the judgment of Judge Abduction?
No.
Or Prinsloo?
No, it's the judgment of, I think, Deputy Judge President Ledwaba.
Yeah.
Yes. So he gave that order, but
thank you.
it was a settlement order, and NPA was not part of the parties that were ordered. It was only the SAPS and some other people. NPA was not part of that settlement. So I could not have been aware.
So you weren't bound by that order because you weren't.
We weren't bound. And remember that order did not interdict the NPA or the magistrate from being involved in the issuing of a warrant of arrest. it was the police who could be held responsible if they knew that this order existed, because each and every day the courts make orders. So you cannot just say, just because there's a certain order that was made against the police, then the prosecutor should know about that order.
You were also subsequently, there seemed to have been a gap because then at paragraph 119, you referred to October 2019 when you again approached by IPID to obtain another statement, which is at M 17 on page 99. To obtain a statement where you were questioned on why you gave questions to your investigating officers to seek clarity from Section 204 witnesses.
Indeed. So, Chairperson, there was this occasion on the 31st of October where I provided a statement where the inquiry was for what was the exact purpose for me providing a list of questions to Brigadier Ngube and General Mabula. So as we have, I have already clarified, this prosecution was a prosecutor-guided investigation. So we already had information from the downloads by then as to what was the role played by different suspects. And now when the 204 witnesses approached the investigating team, showing their willingness to cooperate and to become state witnesses, I wrote several questions that were supposed to be addressed to the 204 witnesses, one of which was whether they are giving their cooperation independently without any undue influence.
Now, it appears from the documents that you attach, Advocate Mashuga, that there was some tension, put it mildly, between IPID and the DPP office. Look at page 101. I think it's M7, page 101. It looks like M17, dated 21 July 2017. This is from the Director of Public Prosecutions, and it's addressed to the Brigadier Ngube, Northwest Provincial Head, complaint against the office of the DPP and IPID members interfering with exhibits handed in on Camille Drift 12/01/2017. So that's about the cell phone.
Yes, indeed, so Chairperson. It's about the cell phone.
It says the cell phone that the DPP letter seeks to obtain from the investigators form parts of court exhibits, and the NPA has no right to order that such exhibits be disposed of. You are not authorized to dispose such court exhibits to anyone except through an order of court. That would amount to defeating the ends of justice. You must give this letter to Colonel Mike Sales, who must take note that he is not allowed to dispose of such court exhibits unless he gets a court order. And this is issued by Mr. Nemarani, Deputy Director of Public Prosecutions. And that is then followed by a letter at page 102 referring to the case, and it is a lengthy letter that's written by at the time Brigadier Ngube, dated 21 July 2017 also. And I'll just summarize, and obviously you can comment at page 104, paragraph 10. You got it, Carl? I'm just summarizing the gist of the letter. It is my view that the DPP instruction concerning the handset of Ms. Sarah Jane Trent was not correct, and it thus compounded the problem. I wish to state that any attempt by any member of IPID or the office of the DPP to remove the exhibit will be seen as an attempt to defeat or obstruct the course of justice, and the necessary criminal case will be opened and investigated.
Indeed, so, Chairperson, in this regard, there was a discontentment that I could detect from the advocates who were dealing with the charge, with the docket that was opened by Sarah Jane Trent and O'Sullivan. So you can see from the instructions that they were given by the same DPP office. Most of the information that they wanted here, it was very easy for them to come to my office and ask me about all these things. Were you the prosecutor who signed the warrant? Yes. What information did you have? They could have given it to them. There was no need. What happened to the cell phone? Is it at the SAP 13? I would have said yes. We are still waiting to download it. But they went around, gave their own instructions. So this now created a situation where it seems that there was tension.
There appeared to be the tension between the Camildrift case,
yes,
which you were prosecuting,
yes,
and the Littleton and Santon case, which was the complaint of Sarah Trent.
Yes,
especially relating to alleged kidnapping, assault, and taking of a cell phone.
Yes, and I must state that other than this instance, generally the DPP office functioned normally without any tensions. But I was also surprised at this. Actually, I even approached Advocate Eric van der Merwe after this and asked him what was the problem with him, and what he said was that, or rather, must I say, he was apologetic about all this.
Now, you do reference the memorandum, which is authored by Van der Merwe and Van Jaarsveld, dated the 31st of May 2017, which presumably informed this request by IPID to secure some, or to obtain some affidavits from you, and that you reference at page 1 of MMM19 on page 105. You got that?
Yes, I've got it.
So the you can see on page 105, memorandum dealing with the prospects of a successful prosecution of certain members of SAPS. Both the case dockets Littleton and Santon relate to the unlawful arrest of Mr. O'Sullivan and his assistant Trent. And then there's a heading with the Littleton case. O'Sullivan was at his office in Johannesburg when a traffic officer came to his office and rang the doorbell and asked him to let him in. She told O'Sullivan that his car was involved in an accident and she's there to investigate. Sullivan refused. She left. This is confirmed by Trent. And then it goes on. Then you are then referred to Advocate Mashuga. There is a transcript of the conversation I'm reading from the bottom of page 105. There's a transcript of a conversation between Spies and Ngube, as well as printed photos that corroborate the complainant's version. Brigadier Ngube apparently applied for the warrant of arrest, the A13. It is not clear, based on evidence that this application was made, it is not clear at this stage whether the person who signed the warrant on behalf of the DPP had any information, evidence available to him, and if so, what. It is not clear who signed the warrant. According to the tape recording, it is Advocate Mashuga. In the directions to the investigating officer, the following was requested: a statement from Willie Spies, the docket in respect of the charges against O'Sullivan supplied by Advocate Mashuga must be obtained. A statement should be obtained from Advocate Mashuga. Although it does not matter why the warrant was issued in the first place, as the main charge should be contempt of court, it is advisable that this information be obtained. So that's in relation to the Littleton matter. Then there's the heading prima facie cases, contempt of court, in that O'Sullivan was arrested despite the court order being shown and explained to them. It will also be able that they were, even before the issuing thereof, aware of the court order, as it was in the public domain and issued in one of the matters where the same investigating team is involved. In this regard, the following is apposite. Prosecutors and police officers are in the employ of the state and have a public duty not to violate a person's right to freedom. It is a fundamental right to an accused not to be detained arbitrarily and without just cause and interference with physical liberty without justification. Then there's a reference to the kidnapping. If no valid warrant of arrest existed, that appears to be the case, it will be easy to prove that the facts of this matter warrant a conviction on a charge of kidnapping. The show of unnecessary force will also be a deciding factor in this regard, and a charge of intimidation will most probably succeed. The fact that the warrant of arrest was requested by an advocate purportedly from the DPP's office will also be of no avail, as there is no evidence to infer that the prosecutor and the arresting officer acted within the authority conferred by a power in question, which in turn requires him or her to take all reasonable precautions to avoid or minimize injury to others. A failure to do so would render his or her conduct unlawful. Fraud and defeating the ends of justice. Then there's a reference to the suspects on page 107, Brigadier Ngube and Colonel Dawood. This involves the arrest of Trent, complainant at the office of O'Sullivan after he left. This is the same day that the traffic officer came to the office. Someone came to the office and arrested her, whereafter she was taken to a Shell petrol station where she met Colonel Dawood, who cuffed her with cable ties. According to her, the arresting officer was Brigadier Khorani. Ms. Trent was kidnapped and kept in isolation at various places without her rights being properly explained. Her cell phone was also stolen from her and illegally tapped. A warrant for her arrest was never shown to her, and she was not afforded the opportunity to contact her relatives or lawyer immediately. The show of force with which she was arrested also paints a clear picture and was totally unnecessary if a valid warrant of arrest on a valid charge was available. It is, however, questionable why an arrest was necessitated on the alleged petty charges. A summons would have sufficed. The possibility that there was no warrant of arrest should be investigated. It appears she was arrested on a whim after O'Sullivan could not be arrested. Then there's a reference to prima facie cases. According to the authors of this document, kidnapping, theft of the cell phone, intimidation. Suspects, Colonel Dawood and Brigadier Khorani. The OB books and registered from Camille SAPS station should be obtained in order to establish who booked her in. This is then the recommendation. Colonel Dawood appears to be a suspect in both dockets. Brigadier Khorani and Ngube appear not to be involved in both dockets. It is possible to investigate further links to connect the various accused and maybe even others in one case. However, the matters can also proceed separately and action can be immediately instituted despite the further outstanding investigation. The dockets already constitute prima facie cases. Advocate van der Merwe and I are therefore of the view that prosecution must be instituted in the regional court. I am aware and have been informed that the decision cannot be made by me and will be taken at another level of authority. I make it clear that in my view, a failure to prosecute will be an injustice to the complainants and the public at large. If it is decided not to proceed with prosecution for whatever reason, care should be taken that the decision will withstand the requirements of noli prosequi certificate. The possible delictual liability of both NPA and SAPS should also be taken into account. So that was signed on the 31st of May by Senior Advocate van der Merwe, DPP Gauteng, and van Jaarsveld, DPP Pretoria.
Indeed, so.
So it's this letter that really gave rise to you being requested to make these further affidavits which you've referred to.
Yes, I would just like to draw this honorable committee to 3.1 and the 3.1
of the annexure.
Yes, of the annexure.
Yes, on page 107. 3.1, under the subheading suspects. Brigadier Ngube and Dawood.
Number 4 from the book, line number 4 from the bottom, which start with, it is however questionable why an arrest was necessitated on the alleged petty charges. So are these petty charges intimidation of witnesses, intimidations of persons, like just the intimidation of any person, including the acting national commissioner of police? Can you really say those are petty charges? So that is why I'm saying there was some animosity against me in relation to that matter. That is why my docket was referred to as petty charges. And secondly, paragraph 2.2, the previous page.
Yeah.
The fact that the warrant of arrest was requested by an advocate purportedly from the DPP's office will also be of no avail, as there is no evidence to infer that the prosecutor and the arresting officer acted within the authority conferred by the power in question, which in turn requires him or her to have taken all reasonable precautions to avoid or minimize injury to others. A failure to do so would render his or her conduct unlawful. They are speaking about me. They are supposed to be colleague. So they are attacking me, even saying that my conduct was unlawful. Remember, they do not have the docket. They do not know what is in my docket. And we now know of the charges of the misconduct of what they had committed. That is why I'm saying that there was an animosity from their side. That is why they could even instruct that our suspects who were part of the Patlane investigation task team should go and obtain a cell phone, which is evidence, which is in the SAP 13, evidence exhibit that was supposed to be downloaded. So once they got hold of the docket, then there would have been a break in the chain of custody. So
there was a.
Oh, sorry, Chair. I've just had my hand up. If the advocate can speak closer into the mic, and I don't know if I didn't miss the first part of your response, Advocate. It was very strong, but you were on a roll, so I didn't want to interrupt. So if you could just that first part and that first part section that you read, because I missed it, please, Chair. And please speak louder because you're allowed to scream in Parliament.
Thank you. I will do it.
Well, not scream, but talk louder.
So what I was referring to is that my docket was referred to as containing petty charges. And I reference here the paragraph that says, it is, however, questionable why an arrest was necessitated on the alleged petty charges. So these serious offenses that I consider as serious were referred to as petty charges. And secondly, there was an attack on me because of this quotation here. The fact that the warrant of arrest was requested by an advocate purportedly from the DPP's office will also be of no avail, as there is no evidence to infer that the prosecutor and arresting officer acted within the authority conferred by the power in question, which in turn requires him or her to have taken all reasonable precautions to avoid or minimize injury to others. A failure to do so would render his or her conduct unlawful. That is referring to me. So I was being attacked here for doing my job, studying the docket, deciding that people should be charged. In fact, this case that was opened by Sergeant Trent and O'Sullivan was nolle prosecute. The DPP declined to prosecute simply because the cell phone was seized in terms of Section 23(1)A of the CPA. So the police were allowed, upon arrest of the accused, to seize the cell phone, number one. Number two, Sarah Jane Trent was arrested and taken to the cells. You cannot say a person is kidnapped when he is taken or he or she is incarcerated in the cells. So that is one of the reasons why the DPP declined. And then there was a representation from IPID after the nolle prosecute to the NDPP. And the NDPP also confirmed the decline to prosecute. Thank you.
Okay. You referenced the fact that at paragraph 122 on page 53 of your affidavit, that Mr. O'Sullivan also wrote an affidavit to the Zondo Commission of Inquiry, and that's at triple M 20.
Indeed, so Chairperson.
Yeah, you want to highlight or emphasize anything there?
Yes. The reason why I annexed the previous annexure, MMM 19, was this MMM 19 was in the hands of Mr. O'Sullivan. So this is an internal memo. This is an internal memo of the DPP office, but it was leaked to Mr. O'Sullivan. And that is why I also reference MMM 20, which is the affidavit of Paul O'Sullivan to the Zondo Commission. And I reference paragraph 31 thereof, which is the second page of the exhibit. And it says that I say that Baloi's decision was unlawful because I was able to get a copy of a letter jointly signed by two senior deputy directors at Pretoria Regional Court who had made a decision that the Mabula squad should be prosecuted on a whole raft of charges, including kidnapping of Trent and theft of Trent's mobile phone. I attached a copy of that letter as Annexure POS 3. Now, importantly, he says here, the memorandum was leaked to me by a whistleblower in Baloi's office who knew that Baloi was up to, but was afraid to speak out. Since the copy I have is hard to read, I have taken the liberty of typing it out verbatim for the benefit of the Commission. The typed version is attached as Annexure POS 4. I request that the annexes be read as if specifically incorporated herein. I now wish to draw the Commission's attention to the following extracts of the memorandum, as the extracts show that the Mabula squad and Mashuga acted with common purpose. And he references the same extracts of the same memorandum that we spoke about. Sure. And just to be clear, Baloi's office, he was referring to the DPP because Advocate Baloi was the acting DPP of DPP by then.
Okay, so take Honorable Sangon.
Sorry. Chair, I feel so stupid asking this question, but I think I must ask it. When we talk about the kidnapping and the arrest, is it one incident?
Yes.
Like, is the kidnapping and the arrest the same thing? So others call it a kidnapping, others call it an arrest. Yes. That's where the cell phone was seized.
Yes.
Oh.
We are taking a break at 1:30.
Thank you, Chair.
And then we will come back at 2:00.
Not going to go into extra time. Advocate Mashuga, so the affidavit of Sullivan triple M 20 that you reference is to illustrate your point that there too appears to be an infiltration because he gets hold of this internal memorandum, which is triple M 19, which we've dealt with.
Indeed, so Chairperson, there appeared to be an infiltration because this memo was made, and then he got hold of this memo, and then he says in triple M 20 that someone in the DPP's office leaked the memo to him. So that shows that he had infiltrated somehow the DPP office because now he was being provided internal memorandum of the DPP. office.
Okay, just then before the break.
What is happening? Is somebody coughing? You must not choke because South Africa is playing this afternoon and we are known as chokers on an international stage.
May I continue?
It was choking, Chair, not joking, choking, like literally.
That's what I'm saying, choking.
Oh, okay.
Not joking, choking. Yeah.
It's actually SA and PA that's choking me.
Pangasita, do you want to say something?
Yes, thank you, Honorable Chairperson. If I'm ahead of the evidence leader, I will apologize. I was actually asking for the explanation with regard to the content of paragraph 118, the 48-hour order. What does that mean? I mean, that Mr. Paul O'Sullivan should be informed, should be given 48 hours notice if he was going to be arrested. Is this a norm?
He obtained a court order to that effect.
Yes, thank you, Chairperson. Yes, he had that order. I do not have a copy, but I know of the contents because I saw it during an agent application that was launched on the date of his arrest. I had to attend to that agent application in the evening. So the order is very clear that before an arrest is made on Mr. Paul O'Sullivan, he must be given 48-hour notice. We were also concerned about that because it means that if maybe, for instance, Paul is committing a very serious offense, the police must first come and give him a notice. So we were very concerned about the effect of that 48-hour notice order.
Thank you, Chair. I don't think the advocate has responded on this Honorable Mvango's question. He was asking if that's normal in a simple term.
No, I would say it is an extraordinary order, but as far as I remember, it was a settlement order. The persons who were, the parties who were cited there were the police and people related to the police, and then the NPA. The NPA did not become part of that settlement order. But on the police side, they are the ones who are settled. So it is a settlement order, meaning that it was agreed between the lawyers of Mr. O'Sullivan and the lawyers of the SAPS.
In other words, we are saying it's only on that occasion. But now, if he has to be arrested now, you don't need 48 hours.
No, it is not only on that occasion. It is perpetual until it is rescinded. It applies.
Even now?
Yes, it applies in any matter. The words I remember that I used there are that in any matter where the police have taken a decision to arrest the applicant, they must give him 48-hour notice.
Then we don't have a judiciary chain in this country. Thank you.
Can we break?
It's on the same matter about the arrest, Chair. It's just clarity.
Okay.
Advocate,
Just wait a moment. Honorable Matthews, Honorable Chopper, Honorable Sangon, and who else? The list is closed. Yes.
thank you. Advocate, please tell us who in SAPS was part of this settlement order. Do you know? And then if not, Chair, I'm going to suggest that we urgently write to SAPS to send us a copy of that settlement order so we can see whose signatures were involved in that. And was it through SAPS National or Gauteng SAPS? Do you know how it?
The settlement order would only contain the legal representatives who were representing them. So they will be the ones that you can get the names of, but obviously you can obtain the information from the SAPS, from their records as to who ordered or who gave the instruction that the matter be settled in that manner. Sorry, Honorable Matthews.
The other part of the question was, I'm not sure, but you clarify, would it have been something that was done from a provincial level or from a national level? How would it have worked?
It would have been done from the national level because the parties that were cited was the National Commissioner and I think General Patlani was also cited. Yeah, there were some parties that were cited. Yeah.
Honorable Sopa.
Thank you, Chair. I'm partly covered by Honorable Matthijs. I just didn't hear correctly. You said the NPA excluded themselves from this agreement, and it was only SAPS that entered into the agreement with O'Sullivan so that he cannot be arrested within 48 hours without permission or with notification.
Indeed, so Honorable, the NPA was cited, as far as I can remember the papers or the order. The NPA was cited, but they did not agree or to the settlement, so they were not part of the settlement.
Thank you.
Honorable Sangon.
Thanks, Chair. I think I'm also partly covered by the two speakers. I just wanted to find out, Advocate Mashuga, would you know what legal authority would have been relied on to be able to grant such an order? Sorry, before you answer, Chair, and then I was just going to request that I don't know if the advocate can assure us that he's got a signed copy of Advocate Mashuga's affidavit, because neither the electronic or the printed ones have been signed. Thank you, Advocate.
Application. So I do not know the facts relating to that, but that it was an application for an interdict. What I could infer from the two orders, because there was not only the one of arrest, there was also the one of a summons, which says that in the matters, and I'm subject to correction, in the matters before or dealt with by the police, the accused or the applicant must be brought to court by way of a summons. So paragraph 2 is the one that says, if it is decided that the accused, the applicant must be arrested, then he must be given the 48-hour notice. So there were those two. So it was an application for an interdict that was settled. So I do not know the facts supporting the same.
Honourable Chair, if I may assist, it is referenced by O'Sullivan, and it's at page 943 of his statement. It's an annexure. Page 943, and it's in a case number in the Gauteng High Court. Case number 75378 of 2016 in the matter between Paul O'Sullivan against the NDPP, Minister of Justice, Minister of Police, Lieutenant General Ashlani, Lieutenant General Shlameza, Major General Mukotedi, Advocate Mayema, Advocate Mlochwa, Warrant Officer Flock. This is the copy of the order. Having read the paper filed of record and by agreement between the parties, but without any admission of liability, and in particular without admission that the applicant is entitled to any relief in relation to Part A, and order in the following terms: any matter, including the charges being investigated under Pretoria Central Case number 380/4/2016, where the first respondent has taken a decision to prosecute the applicant and where a warrant of arrest has been obtained for the arrest of the applicant, the third, fourth, fifth, and sixth respondents, that is just third, fourth, and sixth, that's the Minister of Police, Lieutenant General Ashlani, Lieutenant Shlameza, Major General Mukotedi, undertake to afford the applicant 48 hours notice to present himself at the designated police station. In any other matter where the first respondent has made the decision to prosecute the applicant, the third, fourth, and fifth respondents undertake that the applicant will be brought to court by way of summons. In any other matter where the determination is made that the arrest of the applicant is necessary, third, fourth, fifth, and sixth respondents undertake to afford the applicant 48 hours notice to present himself at the designated police station. We'll make this order available again during the lunchtime. Is that what you were referring to, Advocate Mashuga?
Indeed, so, Chairperson, that was what I was referring to.
If I may just round off just one matter which shouldn't take more than 2 minutes. At paragraphs before lunch, 123, 124, 125, you referred to Brigadier Shlungwani. Just to summarize that quickly, I think that is because Shlungwani, you say that McBride testified in a case that involved him as an accused.
Yes, the reason I am including this paragraph about Brigadier Shlungwani was because it seems that there was some conspiracy against me in all matters, even those in which I wouldn't expect to be linked to Mr. McBride or Paul O'Sullivan. So I say here that I was allocated a case, State versus Mkushani, and I see I wrote 4, but it's 3 others by Advocate Andrea Johnson, when she was still a Deputy Director of Public Prosecutions in DPP Pretoria, where I charged 4 accused persons from crime intelligence, including a general who was a divisional commissioner, a brigadier, and then Brigadier Shlungwani, who was accused 3 in the case, and a Colonel Shlungwani. Shlungwani appeared before this committee as a witness, where he mentioned my name and made all those allegations that I treated him unfairly. In fact, paragraph 124, at some stage, Hlungwane was acquitted in terms of section 174 of the Criminal Procedure Act 51 of 1977, the decision which I launched an appeal against. So I drew up some papers and served the papers on him, but I resigned before the appeal was set down for argument. On 1 August 2024, Hlungwane wrote an email to me demanding service of appeal papers which were delayed at the appeal clerk's office. He insulted me in that email, even stating that I did the same with the IPID members. And the only case that I was dealing with that was against IPID members was this Camille Drift case 12/01/2017. And I state that there that this is a clear interference of a prosecutor in terms of section 32(1)(b). And I also penned a letter of complaint to the DPP through my supervisor. And just to make it clear, the reason why I could not myself initiate complaints or open case dockets at that stage, I had information even from Paul O'Sullivan himself that they wanted me to be removed from the matter. I don't know where they got that information that if I'm removed from the matter will not be prosecuted. So they were hailing all these insults in order for me to open a case, and then they would run and say, I'm conflicted, I cannot be a complainant and a prosecutor at the same time. So I knew of that information. That is why I was not keen to rush to open dockets against them. But the evidence is there, the emails are there, so the evidence is there. I can always open a case at any time.
Okay. And that in summary was the reason why you didn't open a case or lodge a complaint, because you didn't want, that was a stratagem as far as you're concerned, to have you removed from the case.
Yes.
Because of a conflict of interest.
Yes, and I would like Chairperson to refer to the relevant annexure. So it's MMM 22, which says that the first email was on 1 August 2024 at 10:08. So Mr. Tiani Hlungwane here says, Dear Mashuga, more than 8 months later, I still await the documents for your appeal. I have always avoided a confrontation with you during the trial, even when you blatantly lied and did your best to delay the trial, even when the late magistrate was still alive. Your aim and that of the people who give you instructions is to leave this thing hanging over my head. If I do not receive documents over the next 2 months, I will report you and your conduct supported by recordings to the leadership of the NPA. You did the same with the IPID members. Your aim is to harass people on behalf of those who give your instructions. You even mention things which have nothing to do with me in that notice of appeal of yours. You are disgusting for a prosecutor, man. You disgust me, man. You are despicable and disgusting. And then on the 2nd of August 2024, he write another email. Illegitimate son of a Northwest police officer. Bring it on. Stop playing politics. And
okay.
It's Brigadier Hlungwane, who testified before you, before this committee.
Yeah, it's Lungwani. At that page 120.
So this is a clear interference and hindering of the prosecutor, and it's a contravention of section 32(1)(b) of the NPA Act. These are the matters that I'm saying that I was avoiding to be conflicted. So now I'm going to follow them up with laying cases. And also on Mr. O'Sullivan, in some of his emails, he also made these suggestions, discriminatory suggestions that I am from Northwest, and the Mabula team is from Northwest. Those allegations in the emails.
Chair, what do you want to say, Advocate Aransa?
No, it's Honorable Chair, I was just looking at you to see whether you want to take the lunch adjournment or whether we should.
Honorable members will come back at 2:30.
Thank you.